Good afternoon to everyone. Good morning, good night, good evening, depending on where you are in the world. I am Wilson Okoy, Team Lead, Legal and New Markets for Empowered and African Youth Foundation. And today we have an all-important topic to discuss entitled The Role of Lawyers in the Success of Startup and SMEs. We have slated and indeed put 3 p.m. as the time for the event, and that is why we are starting now. And without further ado, we wish to welcome some of our members who are already here and those who are yet to come. And also thank everyone for coming. Now, Empowered African Youth Foundation is Africa's network for youth and young entrepreneurs. And in line with our vision, what we are doing is ensuring that youths around the world, particularly African youths, have the opportunity to learn and develop their skills in the areas of business, marketing, and the like. Our vision is basically to build Africa's largest brand, and we have a diverse network of different professionals from around the world, be you lawyers, medical doctors, accountants, including from places like Nigeria, Ghana, Sierra Leone. And our pillars are basically entrepreneurial education and capacity building, and it will be great for you to engage with us. Our platforms are very dynamic. We are on Instagram, Facebook, Twitter, LinkedIn, and you can find out more if you visit our website, EAYF.org. Now, in line with our aim and vision, we have slated this webinar, and it is essential at this point to let all our viewers know that we have what we call the EAYF SME Fund. And the EAYF SME Fund is essentially a medium by which we represent our ideas by branding on shirts and other materials to create awareness, right? And the essence of this awareness is to inform the general public and distinguished members that we are not just African youths. We are empowered by way of our mindset, by way of our thinking, by way of our habits. And it is also essential, and let you all know that we are not just doing it for ourselves, we are also doing it for everyone. So that is why any one of you can indicate interest by purchasing the EAYF branded shirts, and you'll be able to actually win up to 100K. We have something like a raffle going on to encourage youths, and this can easily be done if you purchase the shirt using the link we have displayed, https://flutterwave.com store Empowered African Youth Foundation. So essentially you can buy an EAYF shirt and win big, not just for yourself but for your family, your loved ones. And we have various speakers, distinguished speakers, I must say, for people who are listening from around the world, not just Nigeria. We have Mary Adeyemo. As you can see, her various titles displayed. She's an associate at Banwan Igodalo, a tier 1 law firm in Nigeria, and she's famously known for her dynamics in corporate commercial law practice. And she has also worked with a couple of other top-notch firms in Nigeria, which are remarkably around the world. She's a graduate of law, having attained a series of first-class awards and best graduating student enterprises. And her passion is in terms of education and being an advocate for excellence. Perhaps if I may add a bit of icing to the cake, most recently she was selected as one of the top 10 Rhodes Scholarship finalists for West Africa 2020. So she's been doing things on the top level actually, and then she served in various leadership capacities. She is currently a volunteer with Eternal Hearts Foundation and the Lagos State Volunteer Corps, and in her free time, she's always willing and ready to mentor young lawyers and law students at every level, helping them to achieve their academic career and leadership goals to ultimately change the world positively, one person at a time. The next personality we have to introduce, the most distinguished, Mr. Caleb Oboagwina. Please forgive my linguistics. Mr. Caleb is a founder. He's a founder of Easy Read legal practitioner, and also a teacher and an author. There's barely anyone who would have gone to law school in Nigeria that wouldn't have heard of this distinguished gentleman. He obtained a diploma as far back as 2008, obtained a Bachelor of Laws in 2013, and the gentleman easily found a way to found his own brand by starting up Easy Read Group. It's actually a legal education tutoring group which covers bar final preparation and production of modern and up-to-date reading materials for aspirants to the Nigerian bar. Indeed, we have the next person, Naomi Ekop. Naomi is she's an associate at Alex Legal Practitioners and Arbitrators, quite a very gentle lady. She's regularly involved in legal advisory and transactional work in corporate law, company secretarial work, international trade. She obtained first class at her university level, that's the undergraduate level, and I mean, she also obtained like basically the best student award overall at the law school level when she got called to the bar. She has practiced in various fields. She's an international attorney. She was recently in the UK with Stevenson Howard LLP. You can Google that up if you have the time to. She has quite a lot of experience in marine and international trade, commercial litigation, and the like. She has received various awards, and notably, we have the African Legal Awards 2020 and Newcomer Award category for Most Promising Private Practitioner. She takes joy in mentoring people, actually, so feel free to reach out to her to enable you get rid of your fears, attain balance and all-round excellence, particularly if you're a student. Now we have the next gentleman, Vika Uguafo. The perfect gentleman engaged in legal officerial duties at Hassao Bank, Abuja. And you get to know that he will actually take us a couple of things on finance and the like later on. He's a lawyer, a chartered arbitration and a humanitarian. Famously graduated from the famous School of Afe Babalola University and has a certificate in corporate finance and corporate finance institutes. And also a certificate from the World Intellectual Property Organization. He is currently a legal advisor or legal officer at Hassao Bank, Nigeria, and has vast experience by working with some top law-notch firms in Nigeria. Most recently, he was part of the team of lawyers who represented the current president, the APC, in the most recent 2019 presidential elections, arguably the biggest elections that we'll hold in Africa. He's held some other notable positions. He's a member of the Nigerian Bar Association and the Nigerian Institute of Chartered Arbitrators. So without further ado, these are the most distinguished panelists, and you are all very welcome once again on here. Perhaps I didn't introduce myself. I'm Wilson Okoye, as you can already see. I'm just my humble self, and I'll be moderating this event, and I am deeply, deeply, deeply honored to be the moderator of this program, and I wish that you will contribute as much as possible in terms of your questions. We don't plan to take too much of your time, so time is value, and in so doing, we'll go straight to the point. We would like to welcome the first speaker. The first speaker, Mary Aguafo, if I pronounce that rightly, to discuss with us on her experiences as far as pre-incorporation and post-incorporation matters are concerned in Nigeria. So feel free, Mary, you are most welcome once again, and everyone on here. Thank you.
Good evening, everyone.
Can you unmute? Thank you.
Good evening, everyone. Once again, my name is Mira Diemo, and I'll be taking us on pre-incorporation and post-incorporation matters under the Newcomer 2020. Please, can I share my screen? Or I don't have to share my screen.
Feel free to.
You can share your screen now.
Okay. Thank you. So once again, my name is Mira Diemo, and I'll be taking us on the, I'll be appraising the Companies and Allied Matters Act 2020, and I've tagged it a catalyst for small and medium enterprises in Nigeria. Before we commence, it is important to note that this piece of legislation is the most progressive piece of legislation under the Nigerian corporate jurisprudence in Nigeria in the last 30 years, as it has, it is geared to propel, SMEs in Nigeria and to also help in the ease of doing business in Nigeria. Again, it's also important to note that the newcomer has gone beyond just having companies, that is private and public companies, limited and unlimited companies, or companies by guarantee. The newcomer has also introduced 2 new corporate organizations, that is the limited liability partnership and the limited partnership, which we may discuss subsequently in the course of this presentation. Again, I also like to state that the newcomer, neither did the oldcomer define SME in itself, but we'll see from the definitions and from the intentions of the legislators, the SMEs can be couched under small companies in Nigeria. So the first question is, what is a small company? What can be defined as a small company? So under the newcomer, a small company is a company which is a private company, and number 2, its turnover is not more than 120 million naira, and its net assets is not more than 65 million naira. So unlike the former Kama, the old Kama rather, this provision has extended the ambit of what will constitute a small company. So many companies within the Nigerian corporate climate can now benefit, can enjoy rights and benefits that come to them as a result of being a small company. Again, another important thing to note under the Kama is the single membership. So if before to form a company, you need at least 2 people to form a company, but now you no longer require 2 people to form a company. Just 1 person is sufficient to form a company, which is very interesting and laudable. Another thing we must note is the, let me quickly say again, for small companies, for you to enjoy the rights and also the probably obligations under the newcomer, you must, like I said, have a turnover that is not more than 120 million. Your assets must not be more than 65 million. None of your members can be a foreigner. So all of your members, they must be Nigerian. And no government or government parastatal or government agency can also be a member of that company. And at least 51% of the shares held in that company must be held by the directors. Again, the share capital of a company has been adjusted under the newcomer. So before now, for a private company, for you to incorporate a private company, you needed what we call the authorized share capital. That is a minimum of 10,000 naira for a private company and a minimum of 500,000 naira for a public company. But under the new provisions, we no longer have anything called the authorized share capital, and that's because there was no value addition by virtue of that word. So now what we have is the share capital and the paid up capital. So the share capital, we are talking about the minimum share capital. The minimum you can have is 100,000 naira. So my admonition is to maybe lawyers, business owners, or professionals that are listening to us. One thing you must note is that if your private company is having a share capital of 10,000 naira, you must increase that share capital to 100,000 naira within 6 months. Let me also state that although the newcomer has been passed into law, there's still a problem of when it will become operative, because the Corporate Affairs Commission is insisting that the law will not become operative until same is gazetted. And the federal government is yet to gazette this act or this piece of legislation. So when you're advising your client or when you want to incorporate a company, you have to have this at the back of your mind. There are still some issues around the operation of this law. There are still some issues around the effectiveness of this law within the climate of gazetting the law now or later in the future. But you must have at the back of your mind that if you have a company whose share capital is less than 100,000 naira, you must increase that share capital so as not to be sanctioned under the provisions of the newcomer. In addition, the newcomer provides for a right of first offer. I mean, this for private companies. So for you, if you're a shareholder in the company, you cannot, just transfer your shares to another person. There's what is called a right of first offer. You must make an offer to, the existing shareholders of that company before you can then say, okay, I want to transfer my shares to Mr. A or Mr. B or Mr. C. Let me quickly talk about the issue of having a company secretary and directors and the issues around it. We have seen some, write-up that says that you do not, you don't have to have, you cannot have a company secretary. No, that's not the correct provision of the law. The correct provision of the law is on exemption. So there's a difference between it is mandatory and you are exempted. So all companies are advised. If I'm your lawyer, I advise you to have a company secretary. But it is no longer mandatory for a small company, which you can also say is no longer mandatory for SMEs to have a company secretary. So you can decide on whether or not to have a company secretary. Another thing is that before now, for you have to have at least 2 directors, for a small company. Now you can just have 1. And this is very good. Some of these provisions are geared towards reducing the financial liability and the cost on SMEs in Nigeria. I also like to make a distinction. So previously, under the old law, we used to have what is called the Declaration of Statutory Compliance, and it was mandatory and was to be signed by a lawyer or attested to by a notary public. But now we do not have anything, we don't have anything like any such provision again. What we have now is a statement of compliance that can be signed by the applicant, someone who is applying to incorporate a company, or the agent of such applicants. So you do not need a lawyer in that for you to be able to have or sign a statement of compliance. Again, you have to be careful on what you do. So when the law is very strategic to say you do not need, not that you don't have. So you have to know the distinction between exemption again and what is mandatory. So before now, for a company must have its seal, whether small or large company, you must have a company seal. But now it's no longer a requirement. You can decide to have a company seal, and you can decide not to have a company seal. In other progressive jurisdictions like the UK, having a company seal is not a mandatory requirement. So when companies come to Nigeria and want to incorporate, and you tell them, oh, you need a company seal, they're wondering for what. So it was more aesthetic than real. So there's really no value to probably having a company seal or not. But now you don't have to have a company seal. Another interesting to note about this newcomer is the registration of charges. So before now, under the old regime, under the old CAMA, for you, for you to register a charge at the CAC, you needed to, pay a filing fee of 1% of the value of that charge. But now there's a 65% reduction. So all you need to do is to pay 0.35% of the value of that charge as filing fees at the CAC. So as compared to 1% that was obtainable under the old CAMA. For public companies, it used to be 2%, but now is also 0.35%. Again, I already talked about limited liability partnerships and limited partnership. So these are some of the new incorporations or new additions to the CAMA in Nigeria. So now, limited liability partnerships and limited partnerships were somewhat recognized under the laws of Lagos State. And the question as to whether a state government can, legislate on a matter that concerns the nation within its own jurisdiction, there were issues around it, arguments for and against it, but it is well settled now because under the new CAMA, there is a provision for limited liability partnerships and limited partnerships, and these institutions can sue and be sued. The difference between a limited liability partnership and a limited partnership is that under a limited liability partnership, everybody will carry their cross. So you are limited to the liability of your own wrongful act, unlike a limited partner, where you a limited partnership. So you are under a limited partnership, you have a limited partner and you have a general partner. So the general partner is responsible for any liability for the wrongful acts or for anything done, contrary to the law or regulations in business. I'm trying to be time conscious. Again, you have to look at the considerations for having the virtual meeting. I remember vividly that during the pandemic, during the lockdown, we still have the pandemic. So during the lockdown, many companies were restricted or were confused on whether or not they could hold their AGM, especially when their articles did not provide for it, did not expressly provide for it. So for some companies, they had to amend their memos to allow for virtual meetings. And I must say that process wasn't really easy because there were a lot of questions, there were a lot of queries, but now it is settled. You can have a virtual meeting anywhere in the world. And this obviously also reduces cost. If you have attended an AGM before, you understand that there's a cost of the place, there's a cost of getting A, B, C, and D, and there is a cost of organization. But now anybody can join a meeting, can attend a meeting anywhere in the world at their convenience. I must also state that before now, it was mandatory for small companies or any company, to appoint an AGM. But now SMEs are exempted from appointing auditors, rather. They are exempted from appointing an auditor. So you're exempted from appointing an auditor. You don't have to appoint a company secretary. So these are many more filing fees. These are many more. Obviously, reduces the cost of running businesses in Nigeria, and everything is geared towards, improving the ease of doing business in Nigeria. Again, you must note that under the newcomer, the board of the CAC is now more inclusive. So we now have representatives of the Nigerian Association of Small and Medium Enterprises in Nigeria.
Okay.
Again, the operative CAC checklist. The CAC checklist, when you want to incorporate a business with CAC, there are some things that you must make. Now provides for electronic processes, which is good. For economic reasons, also good for climate reasons. So you don't have to do paper. So I think this law is forward-looking. It looks beyond just businesses. It looks at the environment. It looks at a lot of things. It takes a lot of things into consideration. So I think I've been able to, generally talk on the new provisions. I've been able to say that you do not need a company secretary for a small company. You don't have to. You don't need to appoint an auditor. One person can, incorporate a company now in Nigeria. And importantly, if you have a company or you have you're a lawyer to a company and their shareholding is that 10,000 naira, enable to ensure to increase this value to at least 100,000 naira, so as not to be cut off by the arms of the law. I think.
All right. Okay. Thank you so much, Mary. We really appreciate it.
Thank you very much.
That was a very beautiful presentation. And just to quickly note, in a synopsis, the newcomer has introduced divergent, or better yet, different and more updated laws as far as company registration is concerned. It's no more mandatory to have a common seal. Signatures and signing of documents can now be done electronically in line with technology. Small companies can be registered by one person. No requirement for auditors for small companies, and even the introduction of LLPs, limited liability partnerships. For those of you who are legally strictly minded, you might want to check up some sections 26, 80, 98, 271, etc. of the newcomer. Now, the next distinguished speaker we have here is Obuagina Caleb. Please, I had apologized earlier, and I'll do so again just in case, for the avoidance of doubt. Now, Mr. Caleb is the founder of Easy Read legal practitioner, law teacher, and author. He's quite famous down here in Abuja. He is indeed a capital man. He obtained, like I hinted, his diploma in law in 2008. He's the founder of Easy Read, mentors students, teaches a lot, has a wealth of experience, and has authored over 12 books. Basically put, has authored over a dozen books in Nigeria. Quite an ardent writer. Please, Mr. Caleb, you are welcome once again to take us on the essentials of ethics and corporate governance in Nigeria as far as the role of lawyers are concerned, because I think it's an issue of concern for everyone now. So, Mr. Caleb, you have the word.
Okay. Can you all hear me?
Yep.
Okay. Welcome. Good day to everyone in this program. I'll be taking the topic, the Code of Corporate Governance. Can I proceed?
Please do.
Okay. Now, the idea of Code of Corporate Governance in Nigeria has several branches, from the legal framework to the principles, and as well as its directives. Now, in order to understand the Code of Corporate Governance in Nigeria, we have several subtopics such as directors and secretaries, we have minority protections, and we have auditors and membership. So basically, I'm going to be defining Code of Corporate Governance according to the OECD principle, which is the Organization for Economic Cooperation and Development. Now, according to that body, Code of Corporate Governance is a system by which business corporations are directed and controlled, and the distribution of rights and responsibility among different participants in the corporation, such as board, manager, shareholders, and other stakeholders, and spelled out the rules and procedure for making decisions on corporate affairs. And by doing this, it also provides the structure through which companies' objectives are set and the means of attaining those objectives and monitoring performance. So you can see the Code of Corporate Governance is all about the interaction between the company, its staff, and as well as its stakeholders. Now, this brings us to the legal framework. Now, the Code of Corporate Governance without legal framework is just wishes. Now, in order to remove it from the realm of wishes into the realm of a framework, it is pertinent to note that the corporate governance has received increase of attention because of the high-profile scandals involving abuse of corporate powers, and in such cases, alleged criminal activity by corporate officers through the corporation. Now, there are several codes of corporate governance, and they can be classified into international level and as well as local level. By local level, we mean Code of Corporate Governance as it governs Nigeria. So let's look at the next, which are the international level of the Code of Corporate Governance. At the international level of the Code of Corporate Governance, we have the following checklist of the Code of Corporate Governance. We have one, the OECD Principle of Corporate Governance in 2004. We have the UK Combined Code of Corporate Governance in 2007. We have the EU Combined Code of Corporate Governance in 2011. We have the USA Subnext Oli Act of 2002. And we have the UN Global Compact Business on Human Rights, 2011. Now, for the local Code of Corporate Governance, which is practicable in Nigeria, we have one, the Code of Corporate Governance for bank and discount houses and guidelines for whistleblowing. Now, whistleblowing is the concept whereby unethical issues are being reported, and that is regulated and issued by the Central Bank of Nigeria. We have two, the Code of Corporate Governance for public company in 2011, and is regulated by SEC. Now, SEC here means Security and Exchange Commission. We have three, the Code of Corporate Governance for Insurance Industry in Nigeria, issued by National Insurance Commission. We also have the Code of Corporate Governance for Pension Operators in 2008, issued by the National Pension Commission, known as PENCOM. And lastly, we have the Code of Corporate Governance Telecommunication 2014, issued by the Nigerian Communication Commission, the NCC. Now, the next we're going to be discussing is what are the theories of Code of Corporate Governance. Now, like I said, for the theories to be enforceable, it must be in a legal framework. And if there is no legal framework for this Code of Corporate Governance, these theories or this concept will be called mere wishes. Now, let's look closely at the theories of the corporate governance. We have two theories regulating the corporate governance. We have one, the agency theory, and we have two, the stakeholders theory. Let me explain briefly because of time. The agency theory has to do with the concept of where the shareholders who invest their money in the company should be considered as the principal of the company, while the director, who are the managing team, should be considered as an agent. And if you understand the role of agent and principal, the principal actually directs the agent as to how acts are to be done. Now, for the other theory, we have the stakeholders theory. Now, for the stakeholders theory, this is not just about shareholders, but other parties who plays a key role in the organization of company. Now, these parties include employees. These parties include stakeholders, which are the employees, like I said earlier, the community, the customer, and as well as the supplier. Now, the essence of the stakeholders theory is to create what is called the corporate social responsibility. And like I indicated later, the corporate social responsibility is not a charity organization. So let's look briefly at what the corporate social responsibility look like. Now, the World Business Council for Sustainable Development defines corporate social responsibility as the continuing commitment by businesses to have behave ethically and contribute to the economic development while improving the quality of the workforce. So you can look at the next examples of the corporate social responsibilities in Nigeria. Now, the corporate social responsibility in Nigeria goes to the following. We have one, contributing to economic and social and environmental progress with a view of achieving sustainable development of affected communities. For example, you have the Niger Delta. The Niger Delta are grossly affected by the production made by oil and gas sector. So you can look at that. We also have respect to human rights. We also have development and apply self-regulatory practices. We also have support and upholding good governance and principle and practice and abstaining from any improper local political activity. They are expected to abstain from any form of political activity.
Okay.
Okay, now to summarize the Code of Corporate Governance in essence, like I said, failure to codify or put a legal framework on this Code of Corporate Governance will amount to just mere wishes. And for this purpose, I would like to commend the Companies and Allied Matters Act 2020 for making two notable contributions of the Code of Corporate Governance in the Act. But I'm going to just take only those two. We have one, there's a balance of power and authority so that no individual or coalition of individuals have unfettered power of discretion. Now, by so doing, the chairman of the board of directors cannot at the same time be the managing director of a company. There must be a separation of power. And that has been recognized by Section 265 of the Companies and Allied Matters Act, and I would like to congratulate them for doing so. And we have, lastly, multiplicity of directorship, which has to do with reducing of conflict. Now, what that means is that a director is prevented from being a director of more than 5 companies so as to prevent conflict of interest. And that is also a way of promoting Code of Corporate Governance in Nigeria. And you can see that in Section 307 of the Companies and Allied Matters Act. And like I said again, the Code of Corporate Governance should be looked into further regulation as it can help build relationship between stakeholders and as well as shareholders. And that brings us to the end of my class. Thank you.
Wow. Thank you so much, Mr. Caleb. We really appreciate that. Was very succinct, that was very elaborate, and indeed that was very incisive. Permit me to also add insightful. Indeed, corporate governance, as far as it's concerned, is very much relevant to startups and SMEs because if corporations are not able to govern themselves, as it were, then how may they be able to contribute their own quota in corporate respects to the society? So it's also essential that as lawyers, because technically we also have to be legally minded, we also have a perspective on the role of lawyers, the rules of professional conduct, how we are expected to treat our corporations when we deal with them, when lawyers are dealing with SMEs, how we provide advisory, just like you are doing now, although in a free manner, so to say, which we don't constitute legal advice, as it were. But it is generally nice to encourage startups and SMEs to say, well, if you have to deal with a lawyer, you need to also take the hints of the lawyer. You need to be aware that as an SME, you have certain burdens, you have certain responsibilities, and this is what will now till us into the next stage of the conference. We'll be inviting a distinguished member of the panel, Naomi Ekop, an associate at Alex Legal Practitioners, to talk about the role of lawyers in businesses and startups as far as it relates to tax. Because it is not enough for a corporate or an institution to just start up, but are you living up to your corporate obligations as far as the law is concerned? And we think that it is very essential for members of the public and even entrepreneurs to know what their obligations are under the law. And for that reason, we'll be going to Naomi Ekop. You're welcome. Once again, Naomi, you have the word.
Thank you very much.
Yes, we can hear you.
Really struggling to hear Naomi.
Hello, Naomi, are you there?
No.
We can hear you sparsely. Can you speak up a
Okay.
little bit, perhaps?
Okay. Sorry about that. I think I'll have to put up my video because it may affect my network.
That's calm.
Okay. Hello everyone, thank you EAYF for having me today. Okay, so I'll be talking about the role of a lawyer in ensuring taxes and other regulatory requirements are met at the CAC and other regulatory bodies. Okay, so first of all, I believe the issue of having a lawyer has almost been overflowed and it's not something that should be underestimated at this point. So even though the CAMA says, okay, maybe private companies are exempt from appointing company secretaries, the role of a lawyer is very essential to the success of startups and SMEs. Now, you need to know the kinds of regulatory compliance and authorities that exist. In terms of the regulatory authority, we have general regulatory authorities where we have bodies like the CAC and the FIRS, and then the sector-specific authority, depending on the nature of business being carried out by the SME or the startup. So for the telecommunication sector, you can have the Nigerian Communications Commissions where it has to do with food or drugs. You have NAFDAC, you have the FRSC for commercial operators. You also need to know in terms of the tiers of regulatory compliance, is it to be at the level of federal regulations such as the CAMA and CAC regulations, and then in terms of taxes, is it to be paid to the FIRS or is it at the state level to be paid to different state tax authorities? You also have to consider, is it to be paid at the local level where you have things like tenement rates or signpost and display and advertisement rates to be paid to the local government. You have to consider the remittance. Is it to be done by individuals or by entities, or is it based on transactions? And also the frequency of the regulatory compliance. Is it one of, for example, incorporation, the requirements at the level of incorporation of a business entity, or is it something that's recurrent that you have to do, for example, maybe renewal of a license, annual returns by a company to ensure that the CAMA still sees it as a company that's still in existence. The role of lawyers in regulatory compliance extends to simplifying the process of compliance for the SME or the startup, maintaining registers and records, correspondence with regulatory agencies. Lawyers have to stay abreast of regulatory regimes which are changing. Recently we've had the CAMA, and then before that we had the Finance Act, and then for each sector, you see that daily there are changes as the business terrain changes, the laws are also adapting, regulations are also coming up. So a lawyer will have to stay abreast of that and also keep the SMEs and startups involved, such that you don't have a situation where you are running late on compliance because you didn't know that a new law was enacted. Also to render and file returns like the annual returns that I mentioned, to advise on the requirements, the mode of compliance, and also in cases where the startup or SME may have defaulted already, how they can actually remedy that default and also obtain renewal licenses, permits, and approvals. Now, startups, SMEs, and tax obligations. We know what tax basically is. That's a levy imposed by government. It may be argued that the Nigerian business environment is currently overtaxed. There are a lot of taxes and permits and licenses, so many things to be paid for. And then when should this be paid? Startups and SMEs may argue that, oh, we're not making profit yet. We are not, we need to put it back into the business. We're not broken even yet. But that doesn't count. The law is that you have to be registered within 6 months of incorporation. So once you have done that, from the commencement of business, you don't say, oh, let me wait till a future time before I begin to pay taxes. Taxes have to be paid as soon as you commence business operations. Now, why do you have to ensure that tax obligations are met by startups and SMEs? First of all, and in fact, which should be a sufficient reason, is that it is mandatory by law. It's not something that's permissible, or if you decide to, it's something that's made mandatory by law. So obviously not paying your tax means that you are actually going against the law. And also you need to build a stellar tax profile and establish a culture of integrity and accountability. Where this comes into play is that startups and SMEs are usually on the lookout for investors. Now, investors, particularly multinationals, foreign companies, would always want to know what is their tax policy, what's the tax policy of this business entity. Have they paid their tax? Have they made the appropriate returns and necessary filings? So it's essential that you pay your tax. For example, tax is part of legal due diligence, that when maybe an acquisition is to be done or a merger, it's part of legal due diligence. Now, how do you do that? By first registering with the tax authority, whether at the federal level, the FIRS, or at the state level, and also ensuring that you remit whatever you're meant to remit and at the appropriate time when it's due. And this is done to the federal and state tax authorities as mentioned. Now, why startups and SMEs? There are different reasons why they may say, oh, we don't want to pay or something. And one of this is ignorance. Many do not even know. They just go into business with the idea of, oh, I have this passion, I have this drive, I want to provide this service. And they don't know that, okay, these are the tax obligations that you have to meet as a business entity in Nigeria. There's also the issue of the complexity of the process, the issue of cost, where they want to put back whatever profit they've made into the business, not knowing that they also have tax obligations to settle. And then, well, it's Nigeria, there's the issue of government aversion, where people are like, oh, I pay taxes, what do I gain from actually paying taxes and all of that. Now, these are some of the popular taxes that should be, yes, in the business terrain in Nigeria. So you have the company's income tax. It's based on the annual turnover, or rather the gross turnover of the company, the entity, and small companies are exempted. Now, for the purpose of taxation, small companies are defined as companies with less than 25 million naira as their gross turnover. That is whatever is the inflow of their economic benefits and revenue from their operating activities. And while medium companies are those having a gross turnover of 25 million to 100 million, and they're expected to remit 20%. And while for companies with an annual turnover of above 100 million, it's 30%, and this is remitted, you know, I say that the different tiers. So this goes to the federal tier, and that is the FIRS. There's also the value added tax, which is imposed on the supply of goods and services at the rate of 7.5%. Again, small companies, for the purpose of taxation, are exempted from paying value-added tax. There is also personal income tax, which is for individuals, businesses, partnerships. And there is also the scheme, which is a mode of collection, pay as you earn, where employers basically deduct the personal income tax from the salaries and then remit it. It's paid at the state level. That's so to the various states' internal revenue service. There's also capital gains tax, which is imposed on profits from the sale of a chargeable asset, such as buildings, maybe in the event of an acquisition or a disposition by any manner, and it's 10% on the profit. So profits have to be made from that sale or disposal. There's also withholding tax, which is an advanced, a sort of advanced collection on the income tax of a company. So, for example, if there's a rent, between where it's an individual, the payer, that's the person that, in this case, maybe the lessee, would remit 5% of that and then remit it to the FIRS or SIRS. If it's from individuals, it will be at the state level. If it's from companies, it will be at the federal level. There's also education tax, and small companies are also exempted from paying this. And stamp, of course, stamp duties, which is charged at fixed or ad valorem rates based on the value of the transaction on instruments. Where it is due from companies, it's paid at the federal level, and where it's due from individuals at the state level. Now, like I said earlier, you have to be, the FIRS clarified on when the Finance Act came out, it stated that those small companies are actually exempt from maybe some of these taxes. They actually still have to register with the FIRS to be able to benefit from this, because probably a time will come where they actually grow and their turnover increases, and then they have to start making payment. So you have to register within 6 months of incorporation, and at that point you obtain a tax identification number or a taxpayer ID for individuals depending on the state, and this number is meant to be displayed on every document and is to be used when filing returns at the tax authority. And it's also, by virtue of the Finance Act, it's also to be required when opening a business account for a company or for business activities. Now, tax evasion is something that startups and SMEs may be guilty of, though it's not right, because it will eventually catch up with you. There are penalties for not registering with the appropriate tax authority. There are penalties for late remittance, and there are penalties for non-remittances. And in addition to these penalties, there are also interests that are calculated. So attempting to evade it now, even though the government is quite serious with its clampdown on people and businesses evading tax at this current point, but the startups and SMEs just compound their issues, because these obligations are just piling and just waiting. Then why you require a lawyer, or if you can afford it, go for a tax specialist, is because there are several tax obligations, and each of them has its own calculations that need to be done to ensure you don't of the law. And having a lawyer will also enable you to know the applicable tax to your particular business, and know when to object to an assessment, and also know tax exemptions for your particular business. Thank you very much.
Thank you. Thank you very much, Naomi. We really appreciate that presentation, better yet discourse. Indeed, as Naomi has rightly pointed out, the issue of tax covers the field as far as corporations are concerned, because number one, that is a very juicy area within which the government is able to effectively source income from us towards the quote and unquote development of the country, which at some point one may want to add a question mark to. But at the same time, we believe that it is where the government also places a financial burden or responsibility on companies to fulfill their obligations what is also known as corporate social responsibility. Now, we have looked at incorporating companies. We have also looked at the ethics that should guide companies that have newly been incorporated or businesses that have newly been incorporated. And we have highlighted the most important or one of the most important factors, which is taxation imposed by the government, such as the Companies Income Tax Act, the Petroleum Tax Act for companies, withholding tax, Personal Income Tax Act, amongst others. Now, we'll be going to an all-important issue. When your business is up and running, you have your obligations duly served and all is well. How are you able to keep the business on as a going concern? A lot of entrepreneurs have heard that word, going concern, to keep it running. The all-important issue of finance is at the crux, because without financing, you know, I don't want to say where your business or anybody's business might be heading to. So we have Mr. Vika Oguafor, who I had previously introduced, a distinguished gentleman, fine one for that matter, legal officer of Hassau Bank and also a member of Empowered African Youth Foundation, a lawyer, chartered arbitrator and humanitarian, to come and set the ball rolling as to what and how important financing is important in startups and SMEs. Mr. Vika, you have the floor. Thank you. Mr. Vika, are you there? Mr. Vika, well, pending when he comes on, I'll be expecting your hello. We'll be expecting your hello anytime from now. But pending when we get your hello, we might want to take a few questions from the public. And before that, I just want to remind us all about the link to buy our EAYF shirts at Flutterwave to represent Empowered African Youths. And then we have a question. I think this may go to Mary or any of the distinguished panelists. It says, I commend the organizers of this webinar. This is impressive. This is from Imo Ayara. What happened to the companies registered before CAMA 2020 took effect? I will really appreciate if the slides are sent to participants' email addresses. Okay, I think the crux here is what happened to companies registered before CAMA 2020 took effect. Mary, are you on? Would you like to answer the question?
Yes, I am. I'm not sure if you can hear me. I'm a bit on the road.
Okay, we can hear you.
Okay, so I mean, so companies that were incorporated before the new CAMA, they still have company recognized.
Can you be more clearer, please?
Okay, so for companies that were incorporated.
Oh, I am inclined to believing we may have lost Mary, but we didn't lose the answer, definitely. To succinctly answer your question, actually, what obtains in law? Okay, we can hear you now.
Okay, so I said that for companies that were incorporated under the old CAMA, they are still entities recognized by the law. However, for companies whose operations have been amended by virtue of the law, they must also implement those amendments. And during my presentation, I gave the examples of I gave an example of a small company or a private company. So if when you were incorporated, your share capital was 10,000 naira, your direct share capital was 10,000 naira, and now because there's already an increase to 100,000 naira, you must increase your share capital to reflect the current provision by the law, and that must be done within 6 months of the new law. However, like I said again, there's still a lot of confusion with the CAC as to when the 6 months will start counting. Because right now, when you want to incorporate a company with the CAC, they are still applying the provisions of the old CAMA on the premise that the new CAMA is yet to be gazetted, and as such, is not yet in operation. So for companies, just try as much as possible with a lawyer, an executive in your company, just try as much as possible to update it, within the parameters of the law to avoid sanctions that may accompany shame. Thank you.
Okay, thank you so much, Mary. So we verily believe that that question has been answered. Perhaps I should also draw the mind of the audience and participants to note that there is a survey form on the chat box. I repeat, there is a survey form on the chat box. So anyone who fills out the survey form will have the opportunity to get a certificate. So perhaps you might just want to obtain the certificate by filling the survey form, which will also enable us to serve you better in upcoming events. By way of kind remark, thank you so much, Mary. Once again, trying to see if we can take another question shortly before Mr. Vika, our finance guru, turns up. I see a question for Council Naomi from Gary Austin. Naomi, I hope you are with us. It says, and I read, where a small company makes 26 million naira, will the 20% be on the extra 1 million naira or on the entire 26 million naira? Okay, please go.
Okay, so the 20% will be on the 26 million naira because company's income tax is on the gross turnover. So if 26 million is the entire gross turnover, the 20% rate is going to be based on that 26 million and not just the 1 million extra in addition to the 25 million.
Okay, thank you. So, Mr. Gary Austin, I believe that has been sufficiently cleared. Mr. Vika, are you online now, or should we take another question? Okay. We are looking to see another question. I think we see another question from Laura Kumarires. Forgive me if I didn't pronounce the name rightly. I'm only human. While spending for Mr. Vika, I read, now that there is no need anymore for a lawyer to sign the statement of compliance plus the exemption from appointing auditors, do you think there could be negative impacts on corporate governance, transparency, and compliance? Thank you all from the foundation for this amazing event. Also for the speakers for their clear and objective expositions. So I'll take the issue of the question again from Laura. Mr. Caleb, you might want to answer this. This is pertinent to corporate governance if you're there. It says, now that there is no need anymore for a lawyer to sign the statement of compliance, plus the exemption from appointing auditors, do you think there could be negative impacts on corporate governance, transparency, and compliance? Mr. Caleb, are you there? Okay, Mr. Caleb doesn't seem to be there, but if I may chip in a thing or two about this issue. Now, the issue of corporate governance is very much interwoven to the extent that it's a give and take situation. So it's not just that, okay, a lawyer need not sign a declaration of compliance. I believe this has been done just to ease the administrative bottlenecks that are involved, but lawyers still have a great role to play, because when you talk about corporate governance, it's a continuing term. It's not a corporate government, it's corporate governance. So it's present and continuous. And what happens is, okay, fine, you fill the statutory declaration or you do the needful, but now to get the ball rolling, to set the ball in motion and run the company, you may need an auditor. If it's a public company, small startup public company, you definitely will need a lawyer, because you will have regulations in place. There's what we call regulatory compliance to see whether, oh, you have paid your taxes, right? Or you have filed some returns, what we call annual returns, or you have changed the directors, or you have had an annual general meeting within the first 18 months of incorporation. So in essence, what we are saying is that it's a give and take situation. What has been done is that the statement of compliance and other factors have been, well, so to say, taken care of, right? Just to smoothen and aid the ease of doing business in Nigeria, in line with best practices and international standards. But that is definitely not to say that the role of lawyers has been obviated or has been taken out, or better yet, has been removed from the essence of governing a corporation, as it were, what you will call corporate governance. So to answer the question in a succinct manner, no, it doesn't negatively impact the impact of corporate governance, compliance, and regulatory transparency. Because if you also look at it from a second bird's eye view, you will see that other rules have been put in place for board of directors and governors in banks, or managers in banks. Managers and directors cannot hold more than 5 directorate positions in a corporation once registered. If they do, they will be mandated by law to disclose such, because it will be very likely that there will be a conflict of interest as per the new CAMA of 2020. There are also other rules. We may be inclined to take another question. We are looking out. Mind you, the EAYF online mentorship form is on for all those who are interested, the survey form. Okay, you are welcome. You're welcome, Laura. Thank you very much. I see your responses. Is Mr. Vicar online now for the finance sector? Or perhaps does he want me to shed some light on this all-important issue of financing?
Sorry, Mr. Wilson.
All right, it's okay.
I apologize for I am not used to this Zoom app, and I don't know how to ask my questions or how to share the questions. I've been struggling.
Okay.
Is there like a link where you can ask the question, type in the questions?
Yes, you have a chat box. May we know who is speaking, please?
Oh, Samuel. Yeah, my name is Barrister Samuel. Yes.
Okay. Nice. You're welcome to the floor. All right. I can see you. There's a chat box. If you could chat us up there, that would be great. Perhaps in case the speaker comes in. Otherwise, if you can make your question very succinct, we are hopeful to be able to answer that in view of the time. Time is of essence, and we'll soon be running along if you're not moving with us.
Oh, hello. Yeah, okay, I want to appreciate all the speakers because it was a very enriching webinar. I have actually 2 questions. I hope time would permit me to take it. First is as it relates to the share capital, particularly hinging it on Naomi's part on tax. Now, we are all aware by, some of the novel provisions of this new CAMA is the fact that it somewhat does away with share capital and the tangential implication of that, particularly the provisions on increase in share capital, is that it abandons the old provisions such that you must first increase your share capital, then allot. Now, increase in share capital by the provision of newcomer is in such a way that you allot. The increase is by allotment. So previously, if my share capital was 50 million and I want to increase my share capital, I'll apply, I'll fill the CAC 2.4 and increase the share capital to 100 million. However, now for the increase under the new act, I just allot 50 million extra shares, and that will be the increase following the other provisions. Now, the one question that rings heavy in my head is, as it relates to trying to link it with Naomi's part on tax.
Can you hit the crux of your issue, please?
Is that how then would you pay your stamp duties on following this new increase or this new provision on increase?
Okay, all right. Well, may I say, even before Naomi comes in, perhaps that the purport of this meeting or webinar, so to say, is for startup business and SMEs. But all the same, Naomi, if you are around, can you give us a practical perspective concerning the question he has raised?
Okay, so despite the fact that maybe that's something that will have to be sorted out by different regulatory agencies, in this case, that between the CSC and the FIRS, the stamp duty is usually, should I say, it's paid on the, it was probably paid on the authorized share capital. So if it's the issued, you are going to file your return of allotment still. So if it's based on the issued, now we're talking about issued share capital, the stamp duty is going to be based on that, the issued share capital.
All right, so we believe that your question has been answered, Samuel. All right. I'm looking to see if we have any other questions, perhaps before I go into a little bit of finance, just by way of a brief discourse. Okay.
So sorry, Wilson. Vika is having some technical issues, so he might not be able to join us. When he we can proceed to the questions, the panelist questions.
All right. Okay, that's calm. We understand that. But if I may just add, under the issue of finance, before we jump to the panelist questions very quickly, there's a very new innovation in the Company Income Tax Act, which I would like every member of the public to be aware of, particularly entrepreneurs. If you look at section 16(1)(c) or thereabouts, perhaps if I may quote, it provides that businesses that have a significant presence in Nigeria, although are not registered in Nigeria, so to say, foreign companies, and this is for people around the world, that have a significant presence of doing business in Nigeria will now be liable to taxation digitally. In other words, if you have a corporation that is outside, say for instance, PayPal, example, quote and unquote, and PayPal is not registered as a business or a startup in Nigeria, PayPal can still be liable to finance tax, right? Because the way they do business in terms of their digital transactions, transfer of money, sharing of money, will result in liabilities and consultations with startups and businesses in Nigeria. And therefore, this then makes them taxable by law. That's one of the new innovations, which is very important for those of us who are digitally inclined and may want to know. You may want to read up the Companies Income Tax Act and the Finance Act of 2019 to get some more clarity about this. And now we tilt over very swiftly to the question and answer session. So if Mary, is Mary with us?
Yes, I'm with you. I'm with you.
Great, awesome. So Mary, we spoke about the post-incorporation facets of companies in Nigeria. We are just keen now, perhaps, to better enlighten the general public, the world. What are some of the salient features of the new CAMA, and how will this affect businesses and SMEs in Nigeria, to be particular? If you can just succinctly answer this, would be great.
Okay, I mean, I think my presentation covered this question already, but let me just repeat some of the salient provisions of the new CAMA is actually pro SME, and one of it is single membership. So one person can form a company. Two, you are not mandated to have a company secretary. So, you know, the process of getting either a small firm or an individual to, you know, act as a company secretary is not at a small cost. You know, if you know what I'm talking about. So this is another thing, this is another provision that will enhance the ease of doing business in Nigeria. Again, another provision is the exemption of small companies from having auditors. So you do not need to have an auditor. Again, there are some provisions that CAMA may need to resolve by the issuance of its regulation as provided for under the newcomer. And so when these regulations are out, we are going to be able to determine some queries that have been raised from the newcomer. Another thing is, you are going to be able to benefit from different rights and of course obligations under the new provisions of the newcomer. And again, I think I've covered the major points. You can have one, you're permitted to have at least one director. In the old law, it used to be at least a minimum of 2 directors. For an SME, you can have 1 director. I think that covers it. Yes.
Okay, thank you very much. Indeed, if we may just chip in also, like she has said, there is no need for company secretary anymore under the new karma. Private companies can hold meetings virtually. I think with the advent of the pandemic, definitely under Section 98, 101 or thereabouts, you see that private companies can hold meetings virtually now in Nigeria. So meetings such as the annual general meetings or extraordinary general meetings don't need to be physically held. And then also, foreign companies that wish to participate in business transactions in Nigeria, now this is for people who are watching around the world, there is no requirement to apply to the president anymore for exemption. Now you have the Minister of Trade, who can be applied directly to with the application, and then he takes it up from there, which eases the role of doing business. And even for companies limited by guarantee, I think under Section 26 or thereabouts, companies limited by guarantee, previously the procedure was that you'll have to apply to the Attorney General of the Federation, right, for his consent. But now that can be easily bypassed by publications in 3 newspapers. And then once that sales trail starts out, it could go through.
On that. Hi, Wilson. Can I just expand on that point?
Please do, please do. Okay,
so for such companies, it's not like you have to still seek the consent of the Attorney General. The only innovation of this newcomer is like before the process of obtaining consent will take as long as 6 months, sometimes 3 months, depending on what is going on at the ministry. But now within 30 days, the AG must give consent, and if you don't get a consent from the AG, there's what is called the deemed consent. So you can go on to do what Wilson just said, to make your publications. And again, if further documents are required or are requested from you, for maybe there's a query from the office of the AG, then the 30 days will start counting from the date you receive that, from the date that you update the ministry with those additional documents. So the 30 days will then start counting from that day. So there is a time limit for the AG to give his consent, unlike under the old karma. Thank you, Wilson. Thank you very much.
Thank you so much for clarifying that for our all-important audience. We really appreciate. Now, if we may tilt over to Naomi. Naomi, we hope you are with us.
Yes, I'm here.
Okay, thank you very much, our taxation expert. So we have spoken on the legal relevance of taxation. So in your view, what do you think are the incidences, or basically what is the legal relevance of meeting tax obligations for SMEs and small companies? Because a lot of times you see that people are very reluctant to pay taxes or are trying to avoid taxes, and I believe it's a point you should expand on. What is the legal relevance of meeting tax obligations in Nigeria? Thank you.
Okay, first of all, taxation is mandatory by law. So just meeting that should actually be sufficient. You are abiding by the law. And also, meeting tax obligations, especially for startups and SMEs, makes the entity more attractive to investors, especially when it has to do with multinationals, maybe government enterprises, international bodies. They want to know that you are accountable, that there's transparency, that there's integrity. And having a tax policy, having a tax plan, and showing that, we have been able to meet our tax obligations for the years that we've been in existence, I think that actually goes a long way to securing the attention of investors. And also, like I mentioned earlier, tax is also an aspect considered in legal due diligence when engaging in transactions such as corporate restructuring. So it's actually an important part, really. That's it. So yeah, startups and SMEs really have to pay attention to that and meet their tax obligations.
All right. Thank you so much, Naomi, and to all our distinguished speakers for the time. We want to specially invite Laura. Laura, are you with us?
Yes.
Yeah, we want to specially invite Laura to give us a perspective about law in her own country, how law goes on from. So you can tell us where you're speaking from, and then just a bit of how law goes on with respect to SMEs and businesses in a timely manner, please.
Of course. So thank you. Well, thank you again for the whole event. It was really, really insightful. So I'm speaking from Brazil. I know Jude from the foundation. And so we talked a little bit about our experiences, and we found some things that are similar actually from Brazil to Nigeria. So I'm a corporate lawyer here in Brazil, and I work with corporate law for 2 years now. And I just came from my master's in international business, so I try to see the perspective from the companies as well. So in my perspective here in Brazil, we already have one legal frame for small and medium scale enterprises. So we already have the ability of having one single membership, and we have some things that are now that I see are being implemented in Nigeria. But what I think is really interesting to see the perspective in other countries, to see how we could apply here. I don't know if you have one specific point in that, Wilson.
All right. Okay. Thank you very much. We appreciate that. It's also nice to see that Nigeria is keeping abreast in terms of international best standards and practices, in terms of what is going on in the world, and the developments as per like one director being registered. And in fact, most recently in our CAMA of 2020, we can also see that incorporated trustees and now there's a possibility for ITs like churches, mosques, schools, and the like to merge. Previously, that was only applicable to companies, but that is now applicable to like churches, schools, and the like, associations, foundations, to have what they call basically a merger and acquisition sort of thing. Yeah, so it's great to hear from you, Laura. And we can see some mails here as well. How can we get a clean copy of the CAMA 2020? What is in circulation in the cyberspace is of very poor quality and some parts are black. And yes, Obi, we appreciate your question, and we will also appreciate the fact that you note that we are not the government, perhaps, but what we may be able to do is, if the appropriate quality of desirable standard comes in cyberspace, definitely we may be able to share it, but I'm sure it will be in cyberspace circulation very soon when the government deems it fit. Survey form is not accepting email, Gary Austin. We'll encourage you to try again, maybe the network on your end, because we have had some successful registrants. Yeah, and perhaps if I may just chip in, in terms of finance, also tax clearance certificate, which used to be previously you need to go to FIRS, get some pays for, or get some connects and all that. It's now free. We are saying this freely, or in other terms, pro bono, for personalities who are interested in becoming entrepreneurs and think that, oh, there's a lot of bottlenecks in the process. You can get your tax clearance certificate freely from your relevant states, or at the federal level from the Federal Inland Revenue Service in Abuja. And yeah, now it is also essential that we note that the new karma, so to say, Companies and Allied Matters Act has introduced the possibility or the concept of limited liability partnerships. Prior to now, we only used to have partnerships that can't that are basically unlimited. So people are not limited to the extent of their liability. But now you can have a partnership, an LLP, as operates in places like America, and then you know, your partnership responsibility is limited to maybe what you guarantee to put in, which is a very new innovation and which is essential. At this point, we would like to remind people of the essence that the branded shirt is still on, and once you buy one, there's a possibility of winning about 100K, and this will be channeled directly back into the aims and objectives of the foundation, which is to empower African youths. Yeah, and also, I think I can see a question here.
So just to chip in,
please go ahead.
Yeah, Wilson, thank you. For the survey form, in case you're having issues with collecting your email, it has been fixed, so you can go ahead and fill it out. Please, it's very important that you fill out the survey form because it helps us to get better and, you know, deliver better service to you guys. So please check it out and fill it out. Just answer your questions very briefly. Thank you. It's a very short form. Cheers.
Okay, yeah, you're welcome. You're welcome. So, okay, I can see some questions here. Survey form. Okay. Well done. Okay, from Charles Uche Esquire. I can assist in sharing a clean copy of the camera. Well done, EAYF, for this insightful webinar. We are most grateful, Charles Uche Esquire, our learned colleague, so to say. For any of you who is interested, and Charles, you can reach out to us. You can send us an email with a clean copy of the camera. We'll appreciate. If you also feel like responding to Charles or getting directly in touch with Charles or anybody on this platform for the right reasons of empowering African youths or for an associated matter, legit, of course, please feel free. That's why the chat box is available. I would have loved to ask Mary a question again. Mary, are you with us?
Yes, I'm with you.
Okay, thank you so much. So, although we are running for time, but all the same, we would like to know what will you say about the responsibility of businesses, basically, because it's one thing for the government to do for the citizens. Someone famously quoted, I know everybody knows, so I don't want to quote, say it's not enough to ask what you are doing for so and so. What is so and so doing for you? Right? So in that sense now, what can lawyers, SMEs, and businesses do for the polity? What can lawyers, SMEs, and businesses do for Nigeria to improve the Nigerian business sector? What are your thoughts on this, please?
Okay, I think I would just like to, make my answer very short. And I think what lawyers, SMEs, or business owners are required to do for the government really is to be accountable and be transparent. And the essence of having a law really is to ensure transparency and accountability. Would have, heard some NGOs, some churches already, fighting, the implementation of the newcomer based on the laws that talk about regulation of NGOs and takeover of the management of the NGOs, where there are fraudulent issues or misrepresentation or things within that sphere. So, as a lawyer, as an entrepreneur, as an individual, a Nigerian or a human, what you need to do is to ensure that the operation of your business is transparent and there is accountability. Because when these two conditions are met, then there'll be ease of doing business. Then there'll be no need to amend the law, to meet situations where people are trying to, divert attention or to navigate compliance with the law. So we should
comply with the law. We should make sure that everything we do is legal, is within the ambit of the law, legally. So there are things that you can do that the law does not provide for, but can still be legal. And so you have to get a lawyer. So it's very important for you to get a lawyer to be able to do that. Thank you very much. If you want further advice, get a lawyer. Thank you.
You're welcome. That is basically it. If you need further advice, you get a lawyer. We can see Kanyin Onu Fowakan. Forgive me, please. I'm just human. Can you share the survey form on this platform? Yeah, the survey form, if you scroll up, you should see it. We have just been reliably informed that Mr. Vika may not be able to join us, but all the same, we especially want to thank him at least for preparing the slides, which may come to all of us. And then also, I want to thank everyone who has asked a question concerning this all-important subject discourse of businesses and startups in Nigeria. So I also wanted to ask Naomi.
I am Olubenga Fireman.
Okay, Mr. Olubenga, good day
Yes.
to you. Can you hit the nail on the head? If you have a question or suggestion.
Yes, my question is in terms of the provisions of CAMA and the use of common C for small companies. In a situation where a company wants to engage in contract of real estate and there is a need for common C, if the company does not have a common C, how does it contract in real property business?
Okay. All right. Perhaps I will chip in a bit of this, and then if any of the speakers wants to add to this, that will be absolutely fine. Now, the law as it is in CAMA, right, is that it is not mandatory to have a common seal. And then there is also the introduction of an electronic signature. If you look at sections 98, 101 of CAMA 2020 or thereabouts. So this is the law now. And the law is not there for willy-nilly observations. The law is not there for people to speculate about. It's there to be applicable. And in default of same, then there will be sanctions. Now, what will usually operate in business transactions is such that when a new law comes into effect, business transactions need to follow the law and not the other way around. So except parties are voluntarily obliging themselves or contracting to the extent that they must have a common seal, in that instance, then the party will personally, because of his promise to have a common seal, be required to have a common seal. But generally speaking, as it cuts across all startup businesses and SMEs, the new law in place in order to aid the ease of doing business is that you need not have a common seal, right? So if that person has a lawyer and he has a vested interest, by way of free advice now, or free hint, more like it, that person can say, no, this is the position of the new law as relates to this particular transaction. So if we are not having a meeting of the minds of not having a common seal, we, one, may not go into this agreement of real estate, or two, may decide to use another medium of endorsing the agreement on real estate. This could be by way of an electronic signature. This could be by way of a thumbprint. This could be by way of an insignation on the signature part, amongst others. So these are all mediums, but it is not hook, line, and sinker deep that a party must have a common seal, because the law has since changed. I hope this answers or meets your expectations, Mr. Benga. And if any other further issues of discourse get into play, feel free to contact the lawyer, right? Yeah. So that is that. It's 4:28, and we should be rounding up in approximately 2 minutes and keeping up to time with our promise. We once again want to thank everyone for the questions that have come in, and I'm still looking through to make sure that we cross our T's and dot our I's as far as questions are concerned, to make sure that no stone gets unturned. So far, we believe we have been able to answer the questions. So
I want
please go ahead.
Hello everyone. Hi. I wanted to say thank you on behalf of EAYF for everyone who came out today to join us for today's session, to all our speakers, Mary, Caleb, Naomi, and Vika. It's unfortunate that Vika couldn't join us. He's a very smart young man, too, like the rest. But unfortunately, he has some technical issues. And yeah, it's part of the problem we're talking about. If we can fix these things as SMEs, then we'll have better services as well. So thank you guys once again for joining us. And please feel free to fill out our survey forms. Why we included your email is so we can match you with your name and then print out a certificate. It may not come very soon, but it will definitely come. So we thank you guys very much once again. And thank you, Wilson, also for the nice hosting. Thanks.
All right. Goodbye, everyone, and thank you.
Cheers. Bye.
Now. Bye.
Goodbye.
Thank you.
Is there any question? Does anyone have any question? If you have any question, please feel free to still take notes. Thank you. Hello, Wilson.
Yep, I'm with you. Thank you, Kanyin. Thank you, everyone. The issues of the PowerPoint presentation will